All right, so this is number 1, Stephanie McCrea.
McCrea. To the red carpet, face the judge.
And good afternoon. I believe we're on just for sentencing today then.
Yes, Your Honor.
All right, let me just advise counsel that I received materials in advance and I have reviewed them. I received a defendant's sentencing memorandum. I received a state's sentencing memorandum as well as the DOC pre-sentence investigation, which was authored by, I forgot the names, but they are there, Elizabeth Campbell and Brian Ford. So just to let you know, that's what I have received in advance of today, and I assure you I have reviewed those. So that being the case, go ahead, Mr. Hayes.
So as the court's aware, Mr. McCrea pled with no agreement between the parties whatsoever. Each party comes before the court today completely free to argue for what it thinks is the right outcome here. And Your Honor indicated, you've already read my sentencing memorandum, so a lot of what I had to say was already contained in there.
And one question I just had was on the guilty plea statement. It said the standard range was 60 months, so I didn't see an actual range. I just said 60 months.
At that point range, it's just 60 months.
That's what I wanted to confirm. Okay.
Max is
That was not an error then. That was an error.
No, that's accurate on counts 1 through 4. It's just plain 60. Cool. So, the state today is asking this court to impose an exceptional sentence and run the tampering count consecutive to the other 4 counts based on an abuse of trust and free crime. To sentence her otherwise would basically let the tampering or whatever crime you want to point to go unpunished. She would be sentenced the same as she would if she came before the court on just 9 points. On top of that, we have what I would argue to be an egregious abuse of trust. Counsel pointed out, well, the state didn't cite any cases that talk about a teacher-student relationship being the basis for an abusive trust aggravator. I would argue that that is because it's so obvious that no one has challenged it to the point that it has produced published case law. In our society, the student-teacher relationship is a pretty sacred one, and it means a lot, and that person is in quite a position of power, control, influence over the students in that class, and that is what allowed this to happen. It's happening during school hours, at school property on occasion, and for that reason, the abuse of trust here was about as bad as you can imagine. It's been thrown out there by the defense that the court should entertain an exceptional sentence downward. As I briefed, if the court were to do that, I don't believe that would hold up on appeal because there's no nexus between her car accident and anything to say that as a result of it, she can't appreciate the wrongfulness of having this kind of behavior go on. They want to say that she's cognitively impaired, but at the same time, she's not dangerous. Now, you can't have it both ways there. If she's impaired to the point where she just doesn't know right from wrong, then that person is dangerous. In the same token, they want to say that she's cognitively impaired, but despite that, she was still a great teacher and has been for the last couple of years. Again, you can't have it both ways. If you're able to have an adult job that you're high functioning and you're doing well at, then you're not someone that's cognitively impaired to the point that you just don't know right from wrong, which is what is required. One of the cases I pointed out, the defendant had schizophrenia, and even there the court said, yeah, he definitely had schizophrenia, but there was nothing, no expert testimony to tie that to a lack of knowledge, that knowing that this kind of behavior was improper. So for those reasons, the state full-heartedly believes that an exceptional sentence downward just isn't something that's on the table for the court to consider. I've already addressed the abuse of trust and the free crime aggravator, so now I'll just address SOSA. As I indicated in my memo, the victim's parents, who are by definition included in they are a victim as well. The parents vehemently oppose SOSA, and the court has to give great weight to that. And if the court goes against those wishes, then has to enter written findings to that effect, explaining why it did that despite those wishes. The counsel has made note of other cases in the news where a female teacher had received a SOSA. I object to the court even considering those, and aside from that, would even think it's improper for a few reasons. No two sex cases are exactly alike. We have no idea what evidentiary struggles the state faced in those cases. We have no idea how the victims or families felt in those cases. So to somehow say, these people got it, she should get one too, it just doesn't make any sense to the state. I didn't go through and pick every case I could find where somebody didn't get a SOSA in a similar situation, because it wouldn't be proper for me to do that. I don't think it's proper for the defense to go and try and do the converse of that too, especially when they're not even in this county, this court. Also, just put it out there that since he's pointed out all these female teacher cases, that this court has to sentence this case the same as it would if the gender roles were reversed. That's what justice requires, that we look at this without regard to what the gender was, just that by law and by this relationship, what happened here was very illegal and amounted to child rape. If the court were to grant SOSA, that would be just too lenient in this situation. Even after she went on admin leave, before any arrest was made, as it started coming to light, she then went, made a fake Facebook profile, began having conversations with the victim, and continuing to encourage him to lie if he's asked about it and tamper with this witness. So that, coupled with the fact that they had intended to keep this going until he turned 18, just speaks to the fact that any remorse that's happened well after she was charged, and I would say she's sorry that she got caught. Didn't seem to have any issues with remorse while this was all going on. SOSA wouldn't be appropriate for someone who just continues to tamper with a victim, and influence them and manipulate them even after it begins to come to light. And as I indicated in my sentencing memorandum, this has had quite an impact on the victim. Despite what the general public might think, given the gender roles this would have on a victim, this has had a great one. It's shaken his ability to trust in romantic relationships, caused him great ridicule, distress at school. It's had a profound effect on his life. That's not something to be taken lightly. While he, at this point in time, is not taking a position one way or the other, as I would say, then we are left with what is given to us under the definition of victim, and that's the parent's wishes. And although the defense tries to cite things that he said and did, immediately after this came to light, I don't think it's fair to hold him to that. He's a kid. He was still under the influence of what was going on, thinking he was in love, trying to be, I guess, true to that vision he had in his mind. And since then, he's been in counseling, has turned the corner and said, hey, look, what she did was wrong. I was a victim. So his wishes then, what he thinks now should be controlling. And he thinks it was serious and that he does see himself as a victim, but he's also not vindictive. So to say that he once said he was okay with SOSA and that's what the court should take to the bank, just that doesn't sit right. Mother is present. I do believe she wishes to speak to address the court when the court's ready to hear it. Victim is present. As far as I know, he has no desire to speak at this time. But I would just argue to the court again that given what went on here, the relationship, she pled to 4 different counts of rape of a child. On top of that, the tampering, that justifies giving an exceptional sentence, running that tampering consecutively.
Can we have the devices silenced, please, right away? Whoever's got a phone going off? Okay, everybody else, please make sure your devices are off at this time. Thank you. Sorry, Mr. Hayes, go ahead.
For whatever period, well, there's really not going to be any community custody because the court, other than the court could impose, if the court gave a standard rate sentence, which is 60 months, the court could at most just impose community custody for any period of earned release that she had. That's what I am asking the court to do in order that she get sexual deviancy evaluation, not have contact with minors unless it's been approved by DOC or sexual deviancy treatment provider.
So you are requesting community custody of what duration?
Whatever earned early release she should get on those 60 months.
Oh.
DOC would calculate it. Such a sentence has been upheld in the last year or so as being a proper sentence. So that's all the court could literally write. It's just for any period of earned release on a 60-month sentence. The sexual assault protection order for 2 years past whatever sentence the court doles out. If it would be 60 months, it would be 2 years past that. I will check to see my file what the credit for time served is while defense has their chance to address the court. Victim's mother is ready to address the court.
All right, why don't you go ahead and come forward, please, ma'am. Can we have you just slide just a little bit this way, Mr. Thayer?
Which way, Judge?
Well, whichever way they're directing there.
Okay.
Good afternoon.
Hi.
Please, by name, identify yourself, please.
Amy Brock?
Okay, Ms. Brock, you're the victim's mother in this case?
Yes.
Okay, what would you like to say to the court?
Sorry, it's all kind of jumbled. I would just like to definitely address the mistrust issue as far as the fact that I feel that she has proven herself the ability to manipulate people, the ability to read people, and use that. I had conversations with her, which she lied to me and manipulated to me about what they were going to be doing. And I, of course, just automatically trusted because of her being a teacher, which is a life lesson for me as well. But I definitely feel that she has proven that capability to be able to do that. And just because she got caught this time because she had a 15-year-old accomplice and possibly underestimated myself as a mother, I feel that's the only reason why she got caught. And I agree with Colin in the fact that he said that she is sorry for getting caught, but showed us after being caught by making the fake Facebook pages and continuing to be in contact that she had no intention of stopping. Possibly maybe because they thought they could get away with it, I don't know. But I feel that all of those things have proven the fact that she is a very intelligent individual, and I do not feel that SOSA would be appropriate for the things that she has shown us. Also, the light of the fact that if she were a male, would this be looked at differently? Would SOSA even be an option? I'm not sure. So I guess those are my two main things. I was, well, typed out and not jumbled in my head on the paper. But yes, for the most part, that's, I guess, pretty much what I want to say.
Okay, thank you, Ms. Brock. So for our record, to make it absolutely clear, you are opposed to a SOSA disposition in this case.
Absolutely. Yes.
All right, thank you, ma'am. Go ahead and have a seat back. Gallery.
Okay.
Anything further from the state other than the credit for time served calculation, or still working on that?
No, and I don't have that, and it was most likely going to be my request to settle a formal entry anyway, depending on what the court decided to do, and so I just asked them to move that to that point.
All right, thank you. Mr. Thayer.
Well, thank you, Your Honor. Well, we are asking the court to use the SOSA option in this case, and in considering that option, there are many factors the court must weigh. Those include categorically, the general character of the defendant is very important. The magnitude of the crime is important. The nature of the misconduct is important. The relative maturity of the victim is important. What other courts have done in similar cases is certainly important, and the court can consider anything it wants to at sentencing, especially since the purpose of the SRA is to promote some uniformity and sense of proportionality in sentences that are imposed in cases throughout the state. What other courts have done in similar cases is terribly relevant. Also, the court should consider and has to consider any unique factors in the case and, of course, the SOSA criteria. We submit that based on the records and the evidence that we've provided to the court, that all the factors in this case favor use of a SOSA sentence. Starting with the general character of the defendant, Stephanie McCrea has no prior criminal record. She was an excellent and dynamic teacher who worked hard and inspired her students for many, many years. Her overall contribution to the community has been overwhelmingly positive, and the misconduct in this case was completely out of character. Second factor that I think is really important to consider in weighing this is the magnitude of the crime. This is not a Class A felony case. It's not a homicide case. The standard sentencing range for second-degree manslaughter with no prior record is 21 to 27 months. For vehicular homicide by reckless misconduct, it's 21 to 27 months. The nature of the misconduct in this case is also an important factor for the court to consider. The misconduct here was situational, and it evolved from an inappropriate friendship that Stephanie allowed to develop with her student. As Dr. Brewer noted in his report, quote, "The subject is not a predatory, repetitive offender, nor is she pedophilic or criminally oriented." And as Dylan Fowler, the victim in this case, told us when we interviewed him just in June, a couple months ago, not immediately after the crime occurred, he never felt pressured or forced by Stephanie. Instead, there was a time when he felt like he was pressuring her, that the relationship evolved out of a common interest in meditation, that he told her that he wanted to kiss her at some point and felt like he was falling in love with her, that about a month after they first kissed, he mentioned to her that he wanted more, that she told him that they needed to wait until he was 18, and that he told her he didn't think he could wait that long. Looking at the relative maturity of the victim, which is also a factor the court should consider certainly in this case, and it certainly doesn't excuse the misconduct, but it would be one thing if the victim in this case was sexually inexperienced and naive or had mental or emotional deficits or was otherwise especially vulnerable. But based on the evidence that the court has seen and reviewed, that's not the case here. Another factor that's very important for you to consider is what other courts have done in similar cases. And we have provided a case just from last August in Pierce County where the Superior Court judge there used SOSA and imposed a 6-month sentence in a case where a 25-year-old teacher had been convicted and pled guilty to child rape of 2 different students and sexted a 3rd student. And in reading that article, there was apparently no mitigating circumstances explaining the misconduct like there are in this case. Another important factor, and really germane to this sentencing, are there any unique features in this case that the court should consider one way or the other? Well, there really are 3 unique factors in this case. First, there are mitigating circumstances. Stephanie McCrea was trying to cope with a brain injury and had not been herself since the accident in 2012. And you know that because we provided a letter from the associate principal at the high school, Rashonda Waters, where she noted in her letter, quote, "Following her injury, there were dramatic changes in Stephanie's personality, behavior, and mood," unquote. Ms. Waters noted that she had memory problems, that her words would come out in the wrong order, that her reactions were impulsive. Students and some parents noted that she started to act immature, which she'd never done before. She'd always been an example for everyone and was a highly regarded and teacher at the school. And even the students, according to the associate principal, reported that she was acting like a teenager. The doctors who treated her noted that her judgment was impaired, and that this impairment obviously contributed to the misconduct in this case, I think is amply demonstrated by the fact that prior to this isolated aberration, she'd led an exemplary life. She'd never done anything that had caused anyone to have any concerns about her. But after the accident, she was injured and damaged. And that mitigating factor is, I think, crucial in this case. The second unique feature of the case, of course, is the abuse of trust. Certainly that applies here. But that's true in every teacher-student sexual misconduct case, Your Honor. It's not a reason to deny or reject a SOSA option, and it's not a reason for an exceptional sentence. And the final unique factor here is the witness tampering. But the record shows that Stephanie was mentally and emotionally impaired when she did that that she was displaying poor judgment and impulsivity and experiencing problems coping with her life even before the disclosure occurred, and clearly indicated or contributed to what happened, to the misconduct that did happen. And contrary to the state's characterization that she was manipulative, she was in truth, she was injured and impaired. And her response to the crisis of disclosure was impacted by that impairment as well. The legislature has given us some criteria to guide the courts in deciding whether or not the option should be used. There's 6 basic criteria. Whether the offender in the community will benefit from the treatment alternative, whether the alternative is too light and too lenient in light of the extent and circumstances of the offense, whether the offender has other victims in addition to the victim of the offense, whether the offender is amenable to treatment. The court has to consider 5, the risk the offender would present to the community if she were released on probation. And 6, the court has to give great weight to the victim's opinion whether the offender should receive the treatment option. In addressing those 6 criteria, they overwhelmingly favor using the SOSA option. The first one is both the offender and the community will benefit from using this alternative. Obviously, rehabilitation benefits the offender, but it also benefits the community. If the offender benefits from the community, then the risk of reoffense is reduced. And reducing the risk of reoffense to the community, I would submit, is the overarching sentencing priority in any criminal case. Someone who has addressed the problem, has engaged in counseling, as she has voluntarily now did for many months, and gets clinical opinion for the court to consider that she's extremely unlikely to reoffend if she's allowed to continue in the counseling that she's being provided, reduces the risk of reoffense to, according to our experts, almost 0. Second, in looking at whether the alternative is too lenient in light of the circumstances of the case, it's not too lenient, first of all, because it's not disproportionate to a case that we provided for the court from Pierce County that was recently the option was used. There are mitigating circumstances in this case, which are, I think, pivotal. Did not exist even in the Pierce County case. And third, anyone who thinks that a SOSA sentence is too lenient has never spent 12 months in the Clark County Jail. That is a horrible experience, especially, maybe not for people who've been to jail many times or have some experience, but for a young woman who has never been in trouble in her life, it is a nightmare. The third factor that the court has to consider is whether the offender has other victims in addition to the victim in this offense. And unlike the teacher in Pierce County, she has no other victims. This was a situational thing, not something that was predatory. The fourth factor is whether the offender is amenable to treatment. Well, both the professionals who evaluated her and provided counseling to her in this case unanimously agree she's amenable to treatment and is an excellent treatment candidate. The fifth factor is to consider the risk the offender would present to the community. Again, the unanimity of clinical opinion that's been provided to the court without contradiction is that she's an extremely low risk to reoffend and won't reoffend, especially if she's provided the opportunity to complete the outpatient counseling. And the sixth factor, to consider the victim's opinion whether the offender should receive treatment. The primary victim in this case has on a prior occasion publicly expressed that he wanted her to he was supportive of the SOSA option, And more recently, when he was interviewed in June, just a couple months ago, he expressed no objection to SOSA. He was indifferent either way. So he did not have an objection to it. And while I empathize with the parents of the victim in this case, the court's in the best position to make the determination after balancing all the evidence and all the factors provided whether or not the public interest would be better served in a given case by using the SOSA option or not. The legislature created the SOSA option just for cases like this, where the record shows that it's unnecessary to send someone to prison for many years to protect the community. And ultimately, the legislature invested the court, not the victim's family, with the discretion and the responsibility to balance all the evidence and the factors and make this determination. On balance, all of the factors, all the criteria, and all the evidence in this case tend to support use of the SOSA option in this case. And we ask the court to impose a sentence based on reason instead of anger, a sentence focused on healing instead of revenge, and one that exalts understanding and absolutely provides this community with its best protection against the risk of reoffense. My client would like to address the court.
Thank you. Ms. McCrea, you have a right of allocution, which is your right to make a statement.
Yes, Your Honor. I take full responsibility for my actions. Every day, I feel the pain of knowing I hurt many people by my choices. I hurt because they hurt. I profoundly regret the hurt that I have caused, and I would give anything to take that back. The shame, the regret, and the guilt that I have is immense. I apologize to those who have been hurt by my choices, especially DWF, his family, my family, and the community. Not a moment passes that I am not thinking of the hurt that I have caused. I am in anguish, and I am in agony. Please know how deeply I have suffered as a consequence of my choices. My son was taken from me, and the unbearable loss that I feel as a mother cannot be put into words. I was his primary caregiver for all 10 years of his life, and he is the most precious thing in the world to me. And now he is gone. My marriage may never be able to be put back together. I lost my home. I lost a job that I loved with every fiber of my being. I have lost everything that I can lose. Every day at the jail, I receive threats and harassment, so much so that I have to be placed on 23-hour lockdown and with no access to programs. I promise you, I will never contact DWF, and I know that his healing is paramount in this. I ask that you grant me the ability to heal too. I seek grace, healing, and forgiveness. Words cannot truly express my regret and my sorrow. Thank you.
Thank you, ma'am. Mr. Hayes, were you able to come up with a credit for time served calculation during?
I was not. That was left out of my file.
All right.
Sorry.
All right, thank you. Appreciate the arguments made by both counsel and the statements by Ms. Brock and the defendant herself. It's a very challenging case from my standpoint. It's a very human condition. I appreciate all the briefing and the argument. I'm going to take about a 3 to 5 minute recess and come back and give you my ruling. Thank you.